Good afternoon and good morning, depending on your time zone. This is Dave Franchina with McGuire Woods, bringing to you this edition of Contaminants Compass CLE series for PFAS and transactions. So let's get started. Let's let me start by I'll do introductions in a second, but let me just thank everyone for joining. This is the next in a series, pardon me, of PFAS-related webinars that McGuire Woods is putting on. I'll remind folks at the end, but there'll be another one of these in August, on August 20th. My partner, Shannon Casely, will be speaking on PFAS and litigation. Just a reminder that when you signed up for this, you hopefully put in details on your bar membership so you can get CLE for this presentation. So please let us know if that poses a problem to you, but it should be pretty seamless getting CLE presentation credit for this presentation today. I want to thank everyone for joining. We have a lot of people here. Over 100 are supposed to sign up and join. So looking forward to the conversation today. That there is an ability for folks to ask questions. We're going to sort of wing it to see whether we deal with questions as we go along or wait to the end. I think we're going to see how the process goes, but please post questions if you like, and we'll do our best to address them either at the as we go along or at the end, just sort of depending on the pace of the conversation. So today we're going to be talking about PFAS in transactions. A lot of this is going to focus on PFAS-related liabilities and how to abate them. I'm going to start off kicking off on federal regulation and protection from liability. Then we're going to go on to phase one environmental site assessments with Caitlin Roanhouse of Geosyntec. Caitlin is a senior principal engineer at Geosyntec. She's been there for nearly 15 years, and she has a strong practice, really stuff that touches dirt, cleanup and liability allocation and brownfields, et cetera. So it'll be good to hear from her and how phase ones fit into liability, managing liability for PFAS. And then we're going to go to my colleague, Matt Giordano, who's going to talk about state law as it relates to PFAS and liability management, including brownfields protections. Matt's an associate with me here at McGuire Woods. Then I'm going to circle back, and it'll be Franchina again. By the way, I'm a partner at McGuire Woods and have an environmental law practice that really sort of spans a lot of various areas, but a lot of it these days is based on PFAS. So we'll have that conversation, and after Matt, it'll be me talking about management of PFAS risks in transactions. Then we're going to kick it over to Jim Vetter, who's the managing director at Marsh and who is one of the leaders of Marsh's national environmental team. And he's going to talk about the perspective of insurers on PFAS risks. Then time allowing, we have some case studies we can go into and Q&A. So with that as our agenda, why don't we get started? There are the presenters. I'm just going to note, I don't know what to make about this, but my father-in-law would have a lot to say about the lawyer smiling and everyone else not smiling. He's never trusted me 100%. So you get a couple smiling lawyers and then Caitlin and Jim. So let's start with a discussion of federal regulation and management of, from a federal level, of protection from liability. So one of the challenges that we run into when we put together these presentations is we try to get stuff done in advance. And ordinarily, that's a really good strategy. However, here, PFAS just kind of keeps rolling on, right? And so we put this presentation together in April. There was an announcement from EPA about what it was going to be doing for PFAS. And then last week, there was another announcement from EPA on what it was going to do with PFAS. So the ball is rolling very fast. Things are moving around a lot. But I'd say one way to look at PFAS and what the federal government is doing these days is start with the Safe Drinking Water Act. And basically what's happened there is that EPA has promulgated some maximum contaminant levels for the two most concerning PFAS chemicals, PFOA and PFOS, PFOA and PFOS. I'll let Caitlin talk more about that, more of the specifics. And just last week, EPA said it was going to stick with having PFOA and PFAS as chemicals with MCLs, and then maybe think again about what they were going to do with several other PFAS chemicals that had an MCL established for them back in the Biden administration. So that's something that we're going to see more of later this year, what EPA is going to do with that. The reason I bring that up as sort of a starting point is these MCLs turn into hazardous substances under CERCLA, which subjects them to cleanup liability under CERCLA. They also flow into RCRA. It's a little bit broader, a broader group there, but they are increasingly being used in RCRA to establish assessment guidelines and to manage hazardous wastes. It flows into the Clean Water Act as well. And what we see increasingly are PFAS being folded into permits issued by EPA and by the states. By way of example, the federal government is still rolling forward with its newest multi-sector individual industrial permit for stormwater, which has a lot of PFAS sampling in it. So far, what EPA is doing there is it is only using PFAS as its monitor only. They're only looking at PFAS and doing sampling on a routine basis. They're not using it as benchmarks. They're not using them as enforceable limits. They're just gathering information. So the thing about the federal permit, the multi-sector permit, is that it's only law in a handful of states where EPA has primacy under NPDES. But a lot of other states will adopt these. And so you're going to see the federal used in a lot of other states, but still other states go their own way. So in North Carolina, by way of example, which is where I live in Charlotte, there is a requirement that if you have certain types of industrial operations, and one of them is landfills, you have to sample for PFAS, and that gets folded into your NPDES permit. So I think what we're going to see from a permitting standpoint is the feds do their things, the states do their things, and a lot of states will follow the federal government, but not all the states will follow the federal government. Finally, on this slide, and I'll move on to the next, manufacturing reporting is increasingly being required under TSCA. This deadline is getting pushed back to next year, but it's more to be seen on that front. So let's take a look at how to manage PFAS liability under federal law. And I want to keep this kind of high level, and I want to focus on one thing in particular, which is basically the cheapest insurance policy you can get for environmental liability, which is the bona fide prospective purchaser defense from liability. So now if you do environmental law, you know that CERCLA applies to 4 classes of liable parties, including current owners and operators of parties. There are defenses to liability, and we have 3 of them laid out here. The innocent owner defense and the contiguous property owner defense depend upon you doing diligence and not finding anything. The BFPP defense allows you to diligence property, find a problem, and then close anyway, right? So you can knowingly acquire property with contamination, and as long as it's in the past, and as long as you follow the other requirements of the BFPP defense, which basically relate to continuing care, then you'll be exempt from federal liability. So it's a nifty defense, and in PFAS world, this is why the prior slide was important. You know, to get the benefit of that defense, the PFAS have to be regulated by federal law. They have to be subject to CERCLA, and so therefore, the intersection of what's a hazardous substance and what's subject to the BFPP defense is important. and it's very much evolving. The keystone to this BFPP defense is doing a phase one that complies with all phase one standards prior to acquiring the property. And for that, I'm going to pass things over to Caitlin, who's going to walk us through the current status of phase ones. Caitlin.
Thanks, Dave. Yeah, so this is about transactions in PFAS. So we're going to dive into PFAS in the context of due diligence. As a refresher, the ASTM E1527 is the standard that EPA has recognized to do a phase one to be in compliant with the AEI rule. These kind of get updated every 8 or so years. The most recent one came out in 2021. It took EPA another year or so to kind of issue the final action that said, we approve this, and it became effective in 2023. So this is the only standard now that is, you're able to use to get these protections. At the time, PFAS were not regulated and were considered an emerging contaminant. And so the way ASTM dealt with that was they talked about it in this appendix called substances not defined as hazardous substances. Well, Dave just kind of mentioned, well, now we have some of the, subset of the PFAS that are hazardous substances. So how do we deal with that now? So the kind of main core of doing a phase one is to identify something called a recognized environmental condition. And at the core of the REC definition is the presence of a hazardous substance or petroleum product. Now, a hazardous substance is defined under CERCLA. You can go into the list of lists. You can look up the number of CAS number to confirm that it is. Well, as of last summer, PFOA and PFAS, only 2 of thousands of these PFAS compounds are now identified as hazardous substances. They are now subject to, being a REC condition under a phase one and getting the CERCLA protections. Well, there are a lot of other PFAS that have regulatory standards in some states that are not considered hazardous substances. So how are we kind of dealing with that? And that's something that you can talk to your client about, and you can address as something called the non-scope item. And how do we do that? We look to the business environmental risk. So a BER is also an environmental issue at the site, but it does not meet the definition of an REC, or recognized environmental condition. And that is going to be something that is not a hazardous substance or a petroleum product. So these other great examples of that are hazardous building materials, molds, methane, things along those lines, and then these emerging contaminants. So you kind of have this weird gray area where we have 2 of, like I said, thousands that may satisfy the hazardous substance designation and can be subject to being an REC. And then we have all these others that may be, a business risk to a client because they're going to be regulated down the road as a hazardous substance, or because the states are regulating them. In that case, we often refer to those as a BER in our reports. A little bit of word of advice on these. I will never put a business environmental risk into a report and finalize it and send it to my client, because sometimes people do not want things in writing. So this is a conversation that the attorney and the user of the phase one has with a consultant. We say, kind of, here's some other risks we've identified. Do you want these memorialized in this phase one or not? So I highly recommend having that conversation offline. Okay, so now we know how to handle hazardous substances and PFAS in a phase one. Well, how do we identify if there are even PFAS at the site and if there has been a release? There are a myriad of industries that have manufactured or used or potentially have disposed of PFAS at their site. So it's really understanding what those are. This graphic here on the left has kind of a bunch of examples of various manufacturing. We're seeing it a lot in textile and electrical or chemical manufacturing facilities. A lot of these old mills are becoming redeveloping as brownfield sites, and we're seeing PFAS there. Landfills, as Dave mentioned, they're being asked to monitor for that. So we're seeing it at some of these closed landfills. Some other examples that I have here on the right are AFFF, which is the firefighting foam. So we're seeing releases of that from the training facilities, from government military properties, and even actual locations where there was a fire and they use AFFF to put that out. You could have a PFAS issue. These wastewater dischargers are going to the plants, and the plants have historically not been able to treat for PFAS. So we're seeing it not only at these sites because of the lagoons, but also in the biosolids where they're spreading the sludge, land application, or even in agricultural sites. So a lot of these old farms, we're seeing PFAS impacts as well. That's really important that we identify kind of the previous uses understand the timing of that. PFAS didn't kind of come into manufacturing until the 30s and 40s, so knowing when these operations are taking place, and then understanding the pathway into the environment. So could there have been a release of the wastewater through old wastewater conveyance pipes? Is it land application of sludge? Is it lagoons? Air deposition is one that people really aren't thinking about too much, but if you have an air permit and you're discharging you PFAS into the air, that could be depositing as well onto the property or nearby. Another way that EPA has really helped us out with this is through the creation of these PFAS data phases. So if you're running, doing a phase one, or using a commercial vendor like an ARIS or an EDR, they're going to be searching these databases. Now, these can be incredibly helpful and kind of be the first, key to the puzzle, but they can also be very misleading and often misinterpreted. So some are as obvious as a PFOA, PFAS contaminated site, which is that first one on the top right. That's very clear. That site has PFOA and PFAS, which are HAZ substances, and it's contaminated with that. That is an obvious recognition for your phase one. Then we get into a gray area of a database that has a known or suspected PFAS detection. Well, that's probably in some sort of facility that is likely to have PFAS impacts, but do we know if they're PFOA or PFAS? So again, that's kind of the starting point where you're going to dig a little deeper and say, we think there may be some PFAS here, but is this a recognition or not? Let's take the next step. And then we have a very ambiguous database, which is called the PFAS IND. What that is that's exclusively based off of the SIC code or the NACS code, which is only industry sector. So this is going to be hundreds of thousands of facilities that maybe fall into the manufacturing code. And that could be a fertilizer producer, and they're not going to have PFAS there. So I've seen a lot of consultants take these and kind of raise a really big red flag, and the lenders get freaked out and everyone gets freaked out, and it ends up being not a big deal at all. So if you're seeing this, your site or a nearby site on one of these databases, it's a good clue to go to take the next step, but it doesn't necessarily mean that you have PFAS at the property or that there was a release. Okay, so now we have maybe done our phase one, we've identified either PFOA or PFAS as a hazardous substances, or maybe we've had a business risk that we want to go do a phase two. So I want to kind of quickly talk through some strategies on what to consider when you're scoping out some sampling. First, PFAS are extremely ubiquitous. They're found everywhere. If you go look for them, you're probably going to find them. So be careful. You really want to focus on the source areas. I talked in a couple of slides earlier on the different types of sources. So the kind of the chemical signature of AFFF is going to be very different than a textile mill, and it's going to be very different than a landfill. So you can take, that chemical signature and only analyze at the lab for a subset of those PFAS to kind of confirm that that's the source, or use that to kind of do some forensics. So kind of consider that, maybe do some background sampling as well. Cross-contamination is a really big issue. When we go out in the field, we can't use, Gore-Tex, we can't wear raincoats, we can't use sunscreen or personal care products. It's in almost everything. So even the water that we're using for decontamination has to be PFAS free. So be really careful, because those false positives, can be above action levels in your samples. When you're generating investigation-derived waste, and that has PFAS in it, where's that going to go? It has to go to a specialty landfill, so keeping that into consideration. The laboratory is important, not only being accredited and running, the right EPA-approved methods or the state-approved methods, but also it's expensive during PFAS, and the turnaround time can be up to a month. So how is that going to fit into your diligence schedule? Talked about forensics a little bit, understanding the different sources. So really takeaway here is have a plan for your data. If we're going to generate it, what are you going to do with it? And I'll just close on this last one about regulatory drivers. Dave and I are both in North Carolina. I gave this talk about a year ago, a little more than a year ago, and this slide looks completely different. It's such an evolving landscape. So it's important to know what your state-specific drivers are, what your reporting obligations are. On the right here is, the top right are the enforceable groundwater standards. A year ago, there was one. Now there's 7. On the left is our soil standards. A year ago, it was half the size of this, and it was all non-cancer based. Now we have a lot more PFAS that are being regulated and have soil cleanup standards. Some of them are cancer based as well. And obviously, as we know, last year, EPA announced the MCLs. So those are now, our drinking water facilities are getting into compliance with that. So, just understanding that this is an evolving landscape. even on a daily basis at a federal level and at a state level. And when you're going and doing your phase 1 and phase 2s, knowing kind of where the current landscape is, so you know what your liability is, you can help your client with that.
Hey,
All right.
hey Caitlin,
Yeah.
this is Dave Franchina. I've got a question for you.
Sure.
Can you help me and maybe others too? What's a good way for a phase 1 reviewer to like me to deal with a phase 1 where you've got somebody when you have a phase 1 preparer who sort of hyperventilates about a potential PFAS risk? Like take the example of the fertilizer plant that you mentioned, right? What do you do if somebody calls a fertilizer plant out as an REC for PFAS where there's no evidence of PFAS use? What's the best way to do that so you don't so a transaction doesn't get sort of wrapped around the axle on a likely trivial risk?
Yeah, that's actually one of my case studies at the end. This exact thing happened to me, and it really almost killed the deal. The lenders did freak out about that. And I think when you're doing a phase 1, whether either you're explaining why something is an REC or you're explaining why something is not, you have to step through the process of the definition of the REC. It has to be a hazardous substance or a petroleum product, and there has to be a release. So go back to the land use. Prove to me that land use had PFAS and then how it got into the ground. And I think that if the consultant's doing a job, that the finding write-up and their opinion will support that, either one way or the other.
Okay, great. Thanks very much. And sorry about stealing your thunder for later on. We'll get there.
Not a problem.
Okay, great.
Right.
Thanks.
I think I'm done here. Matt, you want to take it away?
Sure. Thank you, Caitlin. Appreciate it. So I'm going to take a quick spin through state law, brownfields, and kind of some of the different programs that different states have and whether they're addressing or kind of how they're addressing PFAS. So as background, PFAS regulation varies widely by jurisdiction. So you can kind of put the states into 3 different buckets. So you have the kind of typical leading the charge, heavy regulation environmental states, places like Vermont, New York, New Jersey, California. And then you've kind of got the second bucket of states that have specific PFAS issues. So this would be states like Michigan, Minnesota, and to a lesser degree, North Carolina. And then the third bucket would be kind of driven by the feds, states that are waiting to see what the feds do before making any substantial moves. So that would be states like Alabama, Florida, Texas. So looking at just kind of 2 states to kind of show the differences, take Michigan. So Michigan has this Michigan PFAS Action Response Team, or MPART, and it was established, I believe, in 2016 or 2017. And it's a coordination of 7 different state agencies. So they have basically a coherent response to PFAS. So they set priority industries for PFAS investigation, and many of them line up with what Caitlin mentioned, where it's landfills, airports, military installations, plating operations, places like that have kind of a known PFAS use. And then their initial investigation focused on groundwater. They established a groundwater cleanup criteria, but they're now expanding their investigation into surface water and fish tissue sampling to kind of see where else this PFAS may exist. And then in contrast, you have Alabama. So Alabama, while they have been doing public water system sampling, they've been doing it kind of based on EPA's guidance regarding the unregulated contaminants monitoring rules. And as far as enforceable regulations, they've generally been deferring to EPA. So the focus for Alabama so far has been collecting data versus enforcement actions. And we've seen a little bit of movement where, and I believe Dave mentioned this, where NIPD's permits and industrial discharge permits are starting to see PFAS get folded into monitoring requirements. And then the other change or potential change that Alabama's facing is there was a bill that was introduced in the last few months which would provide ADEM the ability to enforce against public water systems with PFAS detection. So that is still very early on, and that hasn't kind of had much movement, but it shows that Alabama is, I guess, gathering some data and slowly moving towards how to handle PFAS. So turning towards kind of specific states and different programs that they have available, Michigan has a program called the Baseline Environmental Assessment, or BEA. And it's applicable where contaminants exceed unrestricted residential use. And when they exceed that, they're considered a, quote, facility and are eligible for the program. And the program follows a typical environmental investigation where you do a phase 1, you do a phase 2, which is actual kind of poking holes and getting analytical results. And that has to be completed prior to or within 45 days of becoming the owner-operator of the site. And then once you have that data, you have about 6 months of becoming owner-operator to submit that data to EGLE, the Michigan regulatory agency. And you'll get protections under the BEA from the state of Michigan from known and unknown contamination. And Michigan also has an agreement with EPA where unless there's an imminent threat, so think MPL, they won't come in and enforce. And so Michigan, as far as PFAS, has been still kind of feeling it out as an agency. So they have groundwater action levels, and those are captured under the BEA process, but they don't have soil standards. So a soil hit of PFAS alone would not be enough to trigger the BEA process. But what they typically see is that if there's PFAS in soil, there's likely elevated metals. And so the PFAS will kind of get, the facility will still kind of get into the BEA program, even with the PFAS. And most of these BEAs, they're not sampling specifically for PFAS, but you can include it kind of in the scope of your investigation, and it will potentially provide protections if or when Michigan has soil standards that are implemented. So another kind of program available is the comfort letter. And so looking at Indiana, which has a pretty robust comfort letter program and also has the BFPP defense, which Dave mentioned earlier, and it incorporates the federal BFPP by reference. So Indiana offers the comfort letter, which allows, quote, comfort when purchasing a property. So it's a liability clarification, not a legal release, but it's focused on the defenses that David kind of outlined as far as BFPP, but it also looks at enforcement discretion policies in effect in the state. So the process is relatively straightforward, where you kind of fill out their form and kind of discuss prior site use, future site use, and then provide the kind of supporting environmental documents. And IDEM will then evaluate the request and issue a letter confirming that you basically can use the defense or the enforcement discretion that you originally thought you could. And the issue that we see with IDEM is just timing. So even on their website, they say expect to wait a minimum of 120 days. But Dave and I were working on a site recently where we got a comfort letter about 2 weeks ago, and I think we were waiting about a year and a half. So it's a very long review time, but it is a good way to get kind of comfort around property when you're purchasing or entering into a transaction. Another program, which many people are familiar with, is brownfields. So brownfields, as a general matter, is focused on economic development. So they want a property to be safe for use, but the focus is more on getting the development versus an exhaustive investigation. And brownfields generally offers liability protections for redeveloping this contaminated property, and it is applicable or can extend to the prospective purchaser or developer as long as they don't have a prior history or relationship of polluting on the property. And again, these procedures vary state by state, but we can just kind of look at 2 different states and give a feel for the different programs. So turning first to North Carolina, their cleanup standard is the site is safe for intended use. So that goes kind of back to the economic development underlying the whole brownfields program. And the North Carolina process is relatively expensive, and there are long review timelines. Well, I think some of those review timelines are coming down recently, and that may just be kind of less of a backlog, but it generally does take a decent amount of time. And North Carolina, as far as addressing PFAS, they prefer not to have PFAS sampling, but will request it if there's a reason. And by reason, it goes back to kind of the land use industries that we've discussed earlier, where if there's a former land use of electroplating, or there's a surrounding land use of an industry that potentially uses PFAS, then North Carolina will look at the initial application materials and environmental reports and may identify the lack of PFAS information as a data gap, which then they'll go back and mandate sampling. So they'll deal with it. It's not their preference, but it has come up. And then looking at a different state, looking at Georgia, you'll note that the cleanup standard here is a risk reduction standard for soil and source materials. So absent from this is groundwater. The Georgia program provides protection from third-party claims and groundwater cleanup liability. And it's generally, since it's a narrower scope, it comes with a more efficient process. But the issue with Georgia is there's no current PFAS standard or risk levels. So this generally comes from the Hazardous Site Response Act, where PFAS is not listed as a hazardous substance. So at the current time, there's not a limitation of liability if PFAS is identified on site. So those are kind of two different programs and the way that PFAS is potentially being managed. So another program is the voluntary cleanup program. And this is kind of proactive remediation with liability protections, which can include state cleanup, third-party claims, or both. And again, these are procedures that vary state by state, but looking at one, we'll look at Alabama. So Alabama's cleanup standard is residential use or land use controls based on future use. And ADEM, they take a pretty hands-off process, but at the end, you will get a certificate of completion and a letter of concurrence from ADEM. So ADEM is addressing PFAS in a very similar way to North Carolina brownfields. ADEM wants to be kind of part of the team during this process, but they take the similar approach where if there's a reason to look for it, if there's a former land use or if there's a surrounding land use, then they may, but it's going to be treated essentially like another contaminant of concern. So if it's treated similar to the other contaminants, it's going to be folded into the final remedy or final remedial action at the site and will be handled that way. So they're still working out kind of the kinks, much like every other state, on how to handle PFAS. And I believe, Dave, I will be turning it back on over to you to talk about management of PFAS risk in transactions.
Great. Thanks very much, Matt. So let me start by sort of tacking on to what Matt was just talking about getting liability protection under state law through the various means that Matt mentioned. When you add up that and the federal BFPP defense, what you get is an ability to acquire property without environmental liability at the federal level and the state level. Because as you know, if you're a routine practitioner of environmental law, you know that the feds don't usually get involved in most cleanups, right? Usually it's with the states. So if you get liability from the feds and liability from the states with respect to historic issues, then for that piece of property, you're home free with respect to the past, so long as you follow all the requirements to exercise reasonable care and whatnot in the future. So it's when it comes to PFAS, it's a great way to help manage your risk. But as you're hearing, there's, I don't want to say the jury's still out. The PFAS are just now getting regulated, and it's a slow process, and it's sort of going in fits and starts. So, there's an open question as to, the extent to which you'll get complete liability protection, or will it just be for the PFAS that you find? There are some that, some programs give you protection for unknown things, and others don't. So it's something to keep in mind, and it's definitely a place of evolving legal standards. So now let's talk about PFAS in transactional documents. And here what I want to do is to draw a, this slide didn't work out. My apologies on that. There's a little bit of over typing on this slide. Let's separate out asset purchases and equity purchases, right? Asset purchase, you're buying a piece of property. Equity purchase, you're buying a company that owns a piece of property. So with an asset purchase, right, when you are proceeding in a transaction, you get to decide what liabilities you're acquiring and what liabilities you're not acquiring. And generally, parties can allocate environmental risks among themselves. You and I can agree to buy something or sell something, and either I hold on the environmental liability, you hold on the environmental liability, and generally speaking, courts are going to uphold that allocation, right? As between the two of us, a court will uphold whether environmental liability, who ends up with the environmental liability. However, that generally speaking, and there's one big exception I want to talk about in a minute, that generally speaking does not bind the government, right? The government can go after people because of their connections to property and their legal responsibility. So allocating risks between people, that binds the people, but it does not bind the government. They can always go after a responsible party. The one exception in the context of transactions is an asset purchase transaction where you're allocating liabilities and assets. If you are a buyer of something and you do not buy a liability that is excluded from the things you're purchasing when you're purchasing the property, or when you're purchasing a company, you're buying certain assets and you're not buying other assets. If you never acquire a liability, then you can't be held responsible for it. Now, it's a fairly narrow exception, right? It does not apply if you are buying a piece of property, because the liability is going to arise from that property. But if there's a historic liability inside a company and you're just buying certain assets out of that company, and I'll give you an example of this. Let's say you're buying a company and you want to buy the equipment and the records and the intellectual property, but you're not going to buy the liability the company might have for a formerly owned operation. As the liability is kind of kicking around the company. If you don't acquire that liability, then it remains with the old company if it's an asset purchase. And if the government comes knocking on your door as the successor, it's going to have to jump through a lot of hoops to show that you can bear responsibility. And basically, it would need to show that the transaction that you undertook was more like an equity transaction than an asset transaction. But if it's a straight up asset transaction, you're not going to be held responsible for that limited pile of risks, which can be really helpful if you're dealing with a company that, say, back in the day, owned something that worked with PFAS. You can exclude those risks from the transaction if it's an asset deal. Obviously, if you're a seller, you want to get rid of everything lock, stock, and barrel. So there's going to be some pushing back and forth in that. But it's definitely a way to help manage risk. So on this slide, we've pulled apart the typical components of most transactional documents: definition of hazardous substances, a representation on the liability, whether the seller has environmental liability, whether it complies with laws, whether there are hazardous substances present at the property. You can also ask for reps regarding PFAS use. And typically you look to have some sort of discussion about whether you can do an environmental inspection. Here we've noted that most of these things are really important to have, but as you're drafting, most of these provisions, are pretty standard provisions and don't vary much from a situation where there's a PFAS risk from where there's not. A couple that do, the first is the definition of hazardous substances, because as we've discussed, PFAS only now are being regulated as hazardous substances, and only a handful are getting regulated. And so many definitions of hazardous substances that you might see in a purchase agreement won't specifically call out PFAS. And if they don't, and if the definition is a hazardous substance is anything that's regulated as a hazardous substance under federal or state law, you might not get coverage for PFAS. So smart drafting these days is to make sure that when you have all the things that you intend to cover with the definition of hazardous substances, you stick in something that, there's a longer way to say this, that basically says, and all PFAS chemicals as well. So that way, as this area of law grows, your definition will grow too, and you'll get better coverage in the agreement if you're a purchaser, or more responsibility if you're a seller. If you're in a situation where you're dealing with PFAS at a facility and that you're really worried about it, it can also make sense to include specific representations about PFAS and knowledge about PFAS and how the PFAS have been used at the property, and fold that into the agreement so you can get additional protections in the agreement. And when it comes to trying to do environmental inspections, obviously everyone gets to do a phase one of property. It's less important for an equity purchase because you're going to buy everything lock, stock, and barrel, but it's typically helpful to do. But the real debate often is over whether you can do a phase two on someone's property. If you're a seller, you're not crazy about it, because if the buyer walks away from the transaction, you're often stuck with a reporting obligation if you find contamination. And if you're a buyer, you want to know what's there, right? So you need to kick the tires, and doing sampling is an important piece of that. So whether you sample or not ends up being something that is highly contested in transactions where you've got an asset or a company with a high likelihood of contamination. Let's go on to how to manage PFAS risk in transactions. And I'm going to start this conversation and then move it over to Jim, who's going to talk about an important insurance role here. But basically, on top of doing the type of PFAS risk management we discussed already, with trying to limit your liability through defenses, managing PFAS risk in a transaction, can take a couple of different approaches. As I mentioned earlier, you make a series of representations in most transactional documents, and if you breach those representations, you get some sort of indemnification coverage from the other side. Those typically are pretty strictly limited as to time. You only have a certain amount of time to bring a claim. Limited as to, what's going to get covered. Is there going to be a bottom, a basket over which you have to get to get some coverage? And will there be a cap on how much liability coverage you'll be able to get? Another type of indemnification is a specific indemnity. And that would be if you identify a specific risk in a transaction and the parties agree that they're going to cover it, there will be a specific extra indemnity for that matter. So let's say, by way of example, that there's a representation that you never use PFAS on the property. Typically, you're able to schedule around that and say, except as scheduled, we've never used PFAS. But if in fact there has been PFAS use in the property, then that would not trigger liability in that instance because it's been disclosed. What a specific indemnity allows you to do is to drag that back in and give the buyer some protection from that liability for that PFAS risk. As you might imagine, this is very highly contested because most folks don't want to have an indemnification obligation that goes far into the future. This is particularly the case if you're a financial investor in property, say you're private equity. You want to typically get into an asset, run it for 5 to 7 years, and get it sold. The last thing you want is a long-term indemnity of any kind. And so these are all very highly contested and very highly negotiated, but they are keys often to managing PFAS risk. Another approach that people take is to agree to clean up known contamination. There too, this is something that is also very heavily negotiated between parties. There are 1,000 different solutions to it. Some things that parties look to do is to limit what you can look for during cleanup, to restrict who does the work, to develop cost-sharing approaches so that both parties feel the pain of going through a cleanup process, so you're not just spending someone else's money, to impose deed restrictions on the property so that somebody is not cleaning up a property too much. As you might gather, right, there's 1,000 issues that come along with these things, but these are very carefully looked at because these costs can get out of control, and this is one of the real big reasons to do a phase 2 is to try to get a sense of what the financial risk is so the parties can figure out how to allocate it among themselves. I want to talk about one more thing before turning it over to Jim, which is well, a couple more things. One is if you can get a good quantification of risks, there are companies out there that will acquire property solely to get it off your hands in a liability transfer. Oftentimes, you end up writing a check if you're a seller to have somebody else bear that risk long term. There's a lot of insurance that goes into that process, and also a lot of quantification to make sure that everybody agrees what's going to happen with the PFAS or with whatever chemical it is, how it's going to be cleaned up, when it's going to be cleaned up, because you as a seller always have responsibility for that liability. So you're going to want to make sure that the person with whom you're transacting is good for the risk. Finally, let me talk briefly about rep and warranty insurance. Another approach here is to insure over breaches of reps and warranties. This is a product that's been new in the last, say, 5 years or so. People are, insurers are willing to provide coverage for breaches of reps and warranties so long as they're not taking on too much risk. If you've got a site with a material PFAS risk, this is not likely to be a choice you have. But if you've got a site where maybe there's a PFAS risk and maybe it's not, you've not found it in diligence, then rep and warranty insurance, might be something you might be able to get. Although rep and warranty insurers are increasingly carving PFAS out of the scope of coverage they provide in their policies. And then finally, pollution legal liability insurance and other insurance products. And for this, I'm going to turn it over to Jim to discuss the role that insurance products can take in plugging risks in a transaction. Jim?
Thanks, Dave. Let me advance the slide. If there's one takeaway for this section, this is it. There's a lot of information out there that the insurance markets don't have an appetite for PFAS. That is not correct. As you're going to see in the next couple slides, there is actually appetite for insurers picking up PFAS risks. So if there's only one thing you take away from this next series of slides, that's it. There is appetite and potential. So let's kind of move forward. As insurers look at sites, what they're looking for is different industries. For the most part, they're willing to consider PFAS risk across a wide range of uses. If it's direct manufacturing, they're manufacturing PFAS in volume, less so. If we were to go to the bottom, if it's really about landfills, less so. But everything in the middle there, if it's used in manufacturing, if it's a product in the supply chain, if there's AFFF use in fire suppression, product liability, carriers will entertain this risk. So the first screen on the industry, if it's landfills, less so, direct manufacturing, probably not. Everything else news. And as you do, there's two dominant risks we have. The first risk is associated with properties, risks at physical properties. There's also, and we see this increasingly, concern about PFAS in products. In fact, a lot of instances are people are doing transactions, they're picking up businesses that have products with PFAS. What happens if there's liabilities coming in there? Obviously, the properties, but also think about the product liability risk that's associated with it. So those are the two main buckets that the insurers do have appetite with, and they factor in things like social awareness, regulatory environment, costs and uncertainties. And regardless of those three things, they will look at products and properties. The next slide. So with that in mind, how do we position risk and how do these solutions work? The first thing is positioning the risk. With anything with insurance, and especially with PFAS, doing data dumps on carriers gets very little good outcome. The key thing is taking all the information that's pulled together during diligence and presenting it to carriers and using both the attorneys and the technical consultants to present to the insurers. If you think about the typical insurer, they're going to look at something, it's going to go in a pile, they're going to look at it 2 days before. If they have to decipher multiple documents, they may come to the right conclusion, but there's a good chance they may not. Getting the team pulled together to position what the risk is and describe it to them gets you far down the pathway and increases the probability of a good outcome. That's probably the second most important takeaway from today. So as you're positioning risk in products, you're really going to start looking at things that like what were the product or products, what were the dates that they were manufactured and sold, what were the geographies that they were put out, what were the revenues. Revenues are good basis for understanding volume, and were there testing of products. We worked on one transaction where literally the law firm spent 2 months working on this. But if they hadn't done this level of detail and diligence beyond ASTM, it would have never gotten done. So pulling this information together is really critical around product liability risk. If we're talking about the properties, the team has really kind of gotten into that in detail. So now you're pulling together that stuff. How was PFAS used in the process, or maybe not? So being able to demonstrate, just because they've used it doesn't mean a carrier is going to say no. You just have to describe it. And if it's not used, there's situations where carriers will say, well, geez, you had some paper manufacturing process, it was glossy. They may say that's a red flag, but if we can pull MSDS sheets to show that it wasn't used, hey, okay, guess what? Now we're going to consider it. So again, next level of detail on how it was used. Was there a history of firefighting? Were there a history of fires? And then the testing, which the team has talked about, the presence and absence. Has there been investigations? Is it present or not? And even if it's present, maybe there's, again, Caitlin got into it in great detail. Maybe there's offsite sources. And if you can demonstrate there's an offsite source that's responsible, carriers often will not exclude it and will cover it. And even if we do have to exclude coverage on site, there's still the possibility that we can get coverage for off-site migration, third-party bodily injury, third-party property damage, depending upon how well we put together the story about source, pathway, receptor around the site. So, those are the things that are all necessary to basically get a carrier to hopefully say yes and cover your PFAS risk at properties. So, this is the final slide. What's the insurance marketplace? There are a lot of insurers out there that do pollution legal liability. There's only a subset that will do PFAS, but that subset is really capable. And what they've migrated to, we had talked about this 3 years ago, there was a lot of hesitancy to cover PFAS. Now they're getting more comfortable with it. They're underwriting it like any other chemical. Think back to the old days with the MTBE risk. Everybody was kind of freaked out about it, and then all of a sudden everybody got comfortable and it got underwritten. We're in that same place with PFAS. So if you're looking for products coverage, that can either be done as an endorsement to a PLL policy, or there's a specific products pollution policy. They can provide coverage for products that have been used historically and going forward currently, terms up to 1 to 5 years. They can cover distribution in the US as well as internationally. So that's like really good news on the product side. If we look at the property side, that's all about the pollution legal liability that Dave talked about. Carriers are just going to take a nuanced approach. They're going to look at what we know about the site relative to their understanding to say, can we understand this as any other chemical pollutant? They'll look at coverage for 1 to 10 years on a legacy perspective. And in a lot of cases, again, if the team does a good job, doesn't get excluded. But even if it does, we can sometimes get maybe the exclusion limited to on-site. We may be able to get maybe coverage sub-limited. Hey, they don't want to provide the full, say, 10 million limits. Maybe you get 2 million limits. If it's third-party claims that are a risk, maybe it's a per-claimant deductible instead of a one single deductible. Or we see quite a bit. They may say, hey, you got it there, but we just don't want you going out and looking. Don't go investigate. But if a regulator or neighbor knocks on the door, then that would be the basis for a claim. So that would be like a government trigger or a third-party trigger. So if you can live with those type of trade-offs, sometimes a no becomes a yes. Dave, final note here. Dave talked about the liability buyouts. 2 years ago, those firms were really hesitant to pick up PFAS. As Dave said, now they're now willing to consider it. They're now willing to go in, look at it, cover it as part of the concluding point. There is a market for PFAS within the environmental insurers for both products and properties, and it's all about presenting risk. With that, back to the team.
Great, Jim. Thanks very much for that. While I got you, can you help me understand at least if you were going to put out, the various PFAS users that Caitlin mentioned earlier, right? The landfills, the AFFF, the platings companies. What are the hardest types of properties to get insured and the more easy types of property to get insured from a PFAS risk standpoint?
Yeah, the chem producers of PFAS are going to be the toughest. There's a high probability that it's going to be present and it's going to be basically used. That's tough. The landfills are tough. The metal manufacturers, they can be dealt with. I mean, again, you see PFAS being used in some cases for suppression of vapors. But again, if you can provide a source pathway receptor analysis to show that those weren't emitted and didn't get out, or the emissions controls are in place, it's possible to get it covered. So I'd say other than the big manufacturers or landfills, all those other industries are definitely possible.
Great. Thanks very much, Jim.
Thank you.
Let's see. I'm not seeing any questions in the inbox, and we're just about at 1 o'clock. So why don't I take a moment? If there are questions, please pose them quick. If not, let me. I don't think we have enough time for the case studies. Caitlin, thank you for putting them together. Why don't I thank my co-panelists for presenting today. Thanks to the folks that help with the technical stuff, because there's a lot of technical stuff that goes into these things. Thanks to Matt Giordano for getting through this process after losing sound right before he got on the air. That was pretty impressive. Remind me not to play poker against Matt. He had a real poker face. But thanks everyone for showing up for this thing. We hope you enjoyed it, learned a little bit more about PFAS as we go through these various PFAS presentations. Don't forget, in August on the 20th, Shannon Casely will be leading a panel to talk about PFAS and litigation. And with that, we're at an hour, so I'll say thanks everyone for joining, and look forward to chatting with you next time. Take care.